number 3 man in the nation, the Senate President Bukola Saraki, is obviously in for a renewed legal battle. The Court of Appeal has ordered the Code of Conduct Tribunal, the CCT, to conduct a retrial of Bukola Saraki on 3 out of 18 count amended charge on false declaration of assets brought against him by the federal government. The appellate court, in the appeal filed by the federal government against the decision of the Code of Conduct Tribunal that the Senate President has no case to answer, knocked out 15 out of the 18 count charges as incompetent. What does this mean for the Senate President and for the Senate and perhaps for Nigeria's politics? Let's get some perspectives quickly now before we move into our major story of the day. Joining me from our Abuja studio is Dr. West Idahosa, a lawyer and a former member of the National Assembly, a federal lawmaker. Thank you so much for joining us on the program tonight. What is the implication of this judgment? We do understand that the Senate President may be appealing this case to the Apex Court, but for a moment, what does this mean?
Well, the thing is, you know that he never really went into the box to defend himself. What it means simply is that the appellate court thinks that he has a defense to make with respect to 3 of those counts. He needs to make an explanation, and that some discrepancies in the case that had been established against him had been solidified, and a prima facie case exists for him to step into the box and defend himself with respect to those 3 counts. So he will either exercise the option of having to go in there to defend himself or going to the Supreme Court to test the judgment of the appellate court. But usually, when you have had 2 concurrent finding of the lower court and then the appellate court on such a matter, it's always difficult to overturn.
The APC as a party, this is Nigeria's number 3 man, and there's been issues of whether the party or the government of the day is fighting corruption. But yes, we saw what happened when the Senate President kept visiting the CCT and how this case went. Generally speaking, what do you think may happen at the Supreme Court, and perhaps when he does resume at the CCT, and if not, what are the political implications of this?
Well, unlike the trial court, you know, at the appellate level, it's really a lawyer's business. So you are not likely to have him attend proceedings unless he chooses to go there. And he's not likely to disrupt the proceedings of the Senate because his presence may not be very essential to the determination of the appeal. If he does decide to exercise his right of appeal to the Supreme Court, and I think he should do so before he can then await the judgment of the Supreme Court. I'm convinced that the Supreme Court will give some expedient hearing and very facilitated hearing, given the importance that this trial means to Nigeria.
Okay, then, quickly, let's move to another major issues that we're following now. The House of Representatives will conduct a public hearing on the controversial NGO, that's a non-governmental organization bill, which many civil society organizations in the country have kicked against. The Amnesty International is warning that the bill will have devastating effects, but the lawmakers say there is no going back on the bill that has already made it through second reading. What makes this bill controversial? Should NGOs be regulated or should they not? The argument did not start now, neither will it end until the bill is rested or passed. Now let's continue the debate. What does this mean when the people within this NGO system are saying that we do not want this bill? Some other debates are that this will affect even churches and mosques and all the religious organizations. What does this mean holistically for the House of Representatives? It seems the pressure has been mounted for a long time coming.
Well, normally the House is supposed to withstand pressure and then be able to identify which bills are in utmost public interest. I think that the basic thing is that the House has explained clearly that the issues of religion and cooperatives and etc. Are not captured by the bill. They have clearly excluded that, given the sensitive nature of that item. And of course, the small societies, they call it SUSU, and the rest that have been there for a long time have also been excluded. I think the House is principally looking at how they will be a platform for interacting between government and the NGOs. And they think that some of the NGOs are unregulated to the point that they collect funds that are unaccounted for, and that some NGOs also collect funds that are unutilized. And in order to prove this point, they've cited examples of how NGOs collected funds as part of the Northeast development effort and vanished into thin air. Now, we don't know whether this is correct or not, but that's part of the major allegation that the House has made. But be that as it may, it must be understood that the duty to make laws for the peace and good governance of Nigeria squarely rests in the legislature. And to that extent, the best you can do is to mobilize en masse, go to the public hearing, and seek to push your views across to the House. After all, they have a way of receiving memoranda, going through the memoranda, and dealing with it in public interest.